Good morning, everybody. It's gotten really cold here in my part of Virginia. I hope you're having better weather wherever you are. This week, we're talking about something that actually might be of more interest to most of you than what we've been dealing with in the past few weeks, and that is the criminal litigation process. Actually, what happens between the time a suspect is identified and the time that suspect is tried. The readings this week will tell you about most of the aspects of the litigation process that you need to know. I'm going to talk about some of them in this video that perhaps are not fully covered in your readings, and I've also outlined the statute of limitations, in my written announcement that is not in your readings as far as I can find, and it will be on your final project, so please listen to this video if you have time, but certainly read the written announcement as well. Let's get started. Your discussion board this week asks that you find a criminal case, preferably from your own home state, either the state courts in your home state or the federal courts that sit there, involving a motion for change of venue. The purpose of the exercise is for you to understand why such a motion might be brought. But let's talk a minute about what that is. A motion to change the venue of a case is a request by one side of a case or the other, usually the defense, but not always, to move the location of the trial of a criminal case. Now, obviously, you can also file a motion for change of venue in a civil case, but we're not dealing with that this week. We're only talking about criminal changes of venue. As you read about these, you will notice that most of the time there are a couple of main reasons why these are brought. One is because one side or the other, usually, as I said, the defense, but not always, thinks that an impartial jury cannot be impaneled in the location where the trial would normally be held, which, as you know from past weeks, is where the crime was committed. That is the standard venue in a criminal case. Criminal cases are tried where the crime was committed. Doesn't matter where the criminals are from or where they live or where the witnesses live or anything else. All that really matters in a criminal case, until something else does, is where the crime was committed. But sometimes it's impossible or not advisable for a case to be tried where the crime was committed. And that's when a motion for change of venue is filed. As I said, that's usually because one side or the other thinks that an impartial jury can't be impaneled there. Perhaps there's been too much pretrial publicity. Perhaps there are racial or ethnic or religious issues involved with the defendant, so that it's impossible to find 12 impartial jurors. Maybe it's in a very small town or a very rural location where everybody knows each other, or the defendant is related to the judge, or the defendant is related to half the members of the jury panel, which happens, let me tell you. In those cases, it is really more advisable, just from the standpoint of fairness and justice, to move the trial to another location where it's much more likely that potential jurors either are not related to any of the parties in the case, or they haven't heard as much about it, they don't have a personal stake in the outcome, which happens very often in a small community, especially with regard to highly publicized cases. You will talk about changes of venue, motions for change of venue in your final project. But there, we're talking about a motion that's made by a defense counsel almost as a matter of rote. They're not made with any real expectation that the motion will be granted. They're made, to be perfectly honest, so that the defense attorney has covered all of his or her bases and cannot later be sued for being ineffective or for not doing his or her job. That's just, that sounds cynical, but that's really how it is. Now, often I don't want to discount that motion, because often it's made for very genuine reasons, and there are very good reasons to move a trial to another location. But in the vast majority of cases, the motion is made just to make it. You will see that actually in our final project case. There's no real reason to change the venue in that case. It's a bank robbery that occurred in a large city, Washington, D.C. There's probably not that much publicity about it. It's a run-of-the-mill, everyday bank robbery. Not that that's a good thing, it's not, but it's not rare either. So it's not very likely that all the potential jurors in D.C. have any stake in this, in the outcome of this case, or even know about it. So changing the venue there would be very unlikely. I've just given you a major clue, by the way, how to address your final project. I would suggest you take it. Let me talk about one other thing. Here's another clue about your final project. One of the things you'll see on the final project grading rubric is a topic called Statutes of Limitation. Well, there's nothing about Statutes of Limitation in any of your readings that I've ever been able to find. So let me tell you what they are, in case you don't know. A statute of limitations, and I've written about this in the written announcement as well. A statute of limitations is a law, statute, that limits the amount of time a person has, in a criminal case, the amount of time a prosecution has to bring a case. And after that time has lapsed, the case can no longer be brought. It is stale, it's dead. The matter is no longer a viable legal issue. So, for instance, there is a kind of standard. This doesn't apply to every crime, but there's a standard statute of limitations on most federal crimes, and that's 5 years, which means that if a charge for, let's say, mail fraud hasn't been brought against a defendant within 5 years from the date the fraud was discovered or perpetrated, then it can never be brought. It's too old. It can't be done. Now, there are some crimes for which there is no statute of limitations. Those crimes are very rare. Murder is the most well-known of them. In state courts and in the federal courts, there is no statute of limitations for murder. It does not matter how long ago a murder has been committed. In theory, not always in practice for reasons other than the statute of limitations, but in theory, if a murder was committed 75 years ago and a suspect is found 75 years later, the charges can still be brought. Now, obviously, there are lots of practical difficulties there. Witnesses are died. Are died? No. Witnesses have died. Parties that nobody remembers anything about it, probably. But in terms of the law, in terms of legal barriers, there are none. The charges can still be brought. 75 years is a ridiculous length of time. But let's say you have a murder that occurred 30 years ago. Now, that is long past most statutes of limitations for other crimes or other civil actions. But for a murder, it wouldn't matter. If you found a suspect 30 years later, by all means, bring the charge, find the witnesses, hold a trial. It's still a viable legal action. Okay, well, that's enough of that. It's almost 9 minutes into this video, and I haven't even talked about the subject of your short paper this week, which is mandatory minimum sentences and sentencing guidelines. Now, you'll see a lot about those in your readings. Please, please remember as you read and as you write that mandatory minimum sentences and sentencing guidelines are not the same thing. Don't use the phrase mandatory minimum guidelines. There's no such thing. There are mandatory minimums and there are sentencing guidelines. And it is confusing to you and to your readers if you say mandatory guidelines, because a guideline is, by its very definition, not mandatory. It is advisory. So that's the difference. A mandatory minimum sentence is one in which the judge has no discretion, no leeway in whether to impose a certain sentence for a certain crime once the defendant has been convicted. that sentence must be imposed. Now, there are some mandatory minimum sentences that still apply in federal crimes. Some states have also imposed these mandatory minimums. The big controversy about those these days is how they apply to minor drug offenses. We have prisons that are full of people who have not committed violent crimes at all. They've committed very minor non-criminal crimes, really, drug possession and that sort of thing. Most of those sentences are either being commuted or the mandatory minimums are being revised or, revised or eliminated. You will read about those in your readings, and I'd love to hear your opinions on what those are. In fact, that's a requirement. Please do tell me. Sentencing guidelines, on the other hand, are exactly what they sound like. They are guidelines, a recommended range of sentences that a judge can use to try to determine what is the most appropriate length of time to send somebody to prison for the particular crime that's been committed and the particular criminal defendant. Not all criminal defendants are alike. Some are habitual offenders, career criminals that have committed lots and lots of crimes, have served time before, are hardened, and probably should be punished a little more harshly because they haven't learned anything. Some people are first-time offenders, and they may be people who are never likely to commit another crime. And that the sentencing guidelines allow those discrepancies to be taken into consideration, whereas mandatory minimum sentences do not. You will see, I know this video is getting really long and I'm sorry, but I just want to say one more thing. You will see that as you read about mandatory minimums, although they do take away the judge's discretion in applying a sentence or imposing a sentence, they don't take away all discretion. The discretion has unintentionally, but this is what has happened, has shifted from the judge to the prosecutor. And so prosecutors use these mandatory minimums that they know are going to be imposed as bargaining chips for plea agreements. Do we like that? Do we not? Do we think it's efficient? Do we think it's just? These are all things that you'll be allowed to weigh in on and give your opinion about, and I am very interested to hear what you think. Well, I'm going to be quiet now because I've been going on for more than 12 and a half minutes, which is much longer than I usually talk on these videos. But there are some things in this week's topics that the readings don't really fully cover, and I wanted to talk about those. Please play this over and over again, not because it's so wonderful, but because it does have some information that will help you on your final project, as does the written announcement. So have a great week. I'm looking forward to reading your work. Bye.